Good afternoon. The Metropolitan Short-Term Rental Board of Appeals is now in session for its regularly scheduled meeting of July 22nd, 2026. I am Short-Term Rental Property Chief Bonnell McBroom III, and I'll be presenting the cases to the board today for review in today's public hearing. At this time, I would ask everyone to either turn off their cell phones or put them on silent as not to disrupt today's meeting. The procedure will be for staff to introduce the case record. At the conclusion of our presentation, the appellant will present their case to the board along with any person in support. If there is opposition to a case, the board will then hear from those parties. After the opposition has presented their testimony, the appellant will have a period for rebuttal. The board and their rules provide for cases without opposition 5 minutes total for the appellant, including members of the public speaking in support of the appeal to present their case and supporting comments. For cases that have opposition, the rules provide the appellant, including members of the public speaking in support of the appeal, 10 minutes for their total presentation and rebuttal for the opposition's presentation. The appellant must reserve a portion of their allotted 10 minutes for their rebuttal. For members of the public speaking in opposition, 10 minutes is provided. This is 10 minutes total for all speakers combined and not 10 minutes for each speaker. For members of the public that want to submit comments to be entered into the record prior to the meeting that are either in support of or opposition to an appeal, the comments must be submitted to the board staff no later than 5 days prior to the public hearing. Those comments may be sent to strboard@nashville.gov. Documentation supporters or opponents wish to provide to the board after the deadline can be presented to the board members by providing 8 copies at the public hearing. However, the board may elect to defer cases in order to review materials received after the deadline. The Metro Code requires that these proceedings be taped. Therefore, it is imperative that anyone addressing the board come forward, speak into the microphone, identify yourself, and then make your presentation. It should be noted that if it is found that anyone has presented false or misleading testimony to the board that would have affected the board's decision, any approval may be revoked at a later date by means of a show cause hearing. The board will go through the cases set for public hearing today. After both sides of the case presentations are made, the board will discuss and vote on the case. The board is vested with the power to act on these cases before us today under the provisions as outlined in section 6.28.035 of the Metropolitan Code. The code requires 4 members of the 7-member board to be present to constitute quorum. The board's rules require a majority vote in the affirmative of the members present to grant an appellant's application. In the event that a majority vote is not achieved, the case will remain on the board's agenda for the next regularly scheduled public hearing. Applications that fail to receive a majority affirmative vote at the next regularly scheduled public hearing shall be deemed denied by operation of law. Any aggrieved party may, within 60 days of the entry of an order stating the decision of a board resulting from an appeal hearing, appeal the finding of the board under common law writ of certiorari in accordance with TCA 27-9-101 and following to the Chancery Court within the same 60-day period. After that time has elapsed, the board's decision becomes final. No further action can be taken. If you're an appellant and your case is granted, it will be necessary for you to obtain the permit for which you have applied. It should be noted that a permit must be obtained within 2 years for the board approval to remain valid. I submit that all cases have been filed in proper order. The appellants have been notified as required by the code. All affected property owners have been notified, and the legal notification sign requirements have been met as required by the code. Absent any further announcements, we'll be ready to go ahead and advance to our first case today, 2026-020.
Anyone have any announcements? All right, good to go.
Is the appellant present? Yes. Is there any opposition to this case present? Seeing none, the appellant will have 5 minutes to make their presentation.
We'll fix it. No problem. Chancellor, we're going to start with Metro first, but then if you're both going to speak, keep in mind that the 5 minutes is to be divided amongst you, not 5 minutes apiece. Okay?
Okay, this is STR 2026-020, Jacob Petrosky and Tracy Tytko. Jacob Petrosky is appealing 306 Pullen Avenue, owner-occupied permit revoked. The STRP is not the principal or primary residence of the owner permit holder. This is an RS5 zone district. This is governed by BL 2020-187. The decision of the board is whether or not the zoning administrator erred in the cancellation of the permit. Under 6.28.030.A.2 C, to qualify for a STRP owner-occupied permit, the owner of the property shall permanently reside in the STRP, or for conforming uses in single-family and two-family zoning districts, the owner shall permanently reside in a residential unit on the same lot. The owner of the property must be a natural person or persons, may not be limited liability entity, including without limitation corporation or limited liability company, and may not be an unincorporated entity, including without limitation of partnership, joint venture, or trust. The board has discretion under BL 2023-136. On September 21st of 2018, the appellant acquired 1237 GEC Drive, Mayfield, Ohio, 44124, which is an eastern suburb of Cleveland, Ohio. The property tax bill for 2025 tax year has an owner occupancy credit. The explanation of this credit from the Cuyahoga County Fiscal Officer reads as follows. The Cuyahoga County, Ohio owner occupancy credit is a real estate tax reduction available to a homeowner for their principal place of residence. A person can have only one principal place of residence. Since a married couple is presumed to share one residence, only one owner-occupied credit can apply to properties owned by spouses. December 29th, 2023, Jacob Petrosky and Tracy Tytko acquired the property at 306 Pullen Avenue, Nashville, Tennessee, 37207. October 25th of 24, an owner-occupied permit application was submitted for the property. The application was processed and the permit was issued. April the 2nd of 2026, a Hub Nashville request for service was submitted for the property at 306 Pullen Avenue, which stated, they do not live at this address. They moved out of this house and I haven't seen them at this address since that time. Inspector John Feltz opened an investigation. Dr. Petrosky's LinkedIn page lists him as general surgeon resident at University Hospitals of Cleveland, Ohio from 2013 to 2014. As general surgery resident at Cleveland Clinic from 2013 to 2017, and as bariatric surgeon at University Hospitals of Cleveland from 2018 through 2021, as bariatric surgeon at Cleveland Clinic full-time from January 2022 to the present. The appellant's biography in both U.S. News and World Report and Health Grades list him as being licensed to practice in multiple states, including Tennessee. The hospital affiliations that Inspector Feltz found for him in Tennessee, according to his medical license with the state of Tennessee on 4/29/26, are with Baptist Memorial Hospital, Memphis, Methodist University Hospital in Memphis, Methodist Le Bonheur German Hospital, and TriStar Horizon Medical Center in Dixon, Tennessee, with medical offices at 7655 Poplar Avenue, Germantown, Tennessee, 38138, which is in a Memphis suburb. No hospital affiliations in Nashville. His Tennessee medical license listed his address as Mayfield Heights, Ohio. The Cleveland Clinic news release on March 29, 2022 announced that the appellant had joined the Cleveland Clinic Indian River Hospital in Vero Beach, Florida. The address of the Cleveland Clinic listed in the news release is 9500 Euclid Avenue, Cleveland, Ohio. The CMS.gov website, which is a federal government website managed and paid for by the U.S. Centers for Medicare and Medicaid Services, lists the address of the Cleveland Clinic Foundation as 9500 Euclid Avenue, Cleveland, Ohio. On April 29th of 2026, Inspector Feltz found that the Ohio Secretary of State website that the appellant was registered to vote in Ohio with his address listed as 1237 GEC Drive, Mayfield, Ohio, 44124. Also on this date, Inspector Feltz found that there was an Ohio driver's license issued to the appellant on February 23rd, 2021, with an expiration of February 24th, 2025. The appellant's wife, Tracy Tytko, was also registered to vote in Ohio on April 29th, 2026, with her address listed as 1237 GEC Drive, Mayfield, Ohio 44124. There was a Tesla 2021 Tesla Model Y sedan registered the appellant and Ms. Tytko at the 1237 GEC Drive, Mayfield, Ohio address. Ms. Tytko has an active LLC registered with the Ohio Secretary of State. It is Tracy Jean Photography, LLC, for which she is listed as agent with the address at 1237 GEC Drive, Mayfield, Ohio. There is a current website advertisement for a salon named Cleveland Microblade, for which Tracy Jean Photography is credited as photographer for the ad. The salon's address is 8615 Tyler Boulevard, Mentor, Ohio, which is 24 miles east of Cleveland, Ohio. Ms. Tytko's Instagram page contains numerous references to Cleveland, Ohio as the location from 2018 through 2025. There are 4 website advertisements for the property included at the end of the summary package, the last of which lists Tracy as the host and pictures of Dr. Petrosky and Tracy Tytko. The caption for the host photograph reads, lives in Cleveland, Ohio. As of July the 9th of 2026, the caption for the host, the ad remains posted and the calendar is blocked. I included a separate print out of this ad, which shows that it was printed on July 9th of 2026. Metro's compliance contractor, Gronicus Host Compliance, tracking of the website ads posted for the property shows that this was the first ad posted for the property, which was on May the 7th of 2025. May the 5th of 2026, 2 permit revocation letters were sent to 306 Pullen Avenue, Nashville, Tennessee, and 1237 GEC Drive, Mayfield, Ohio, detailing the revocation would go into effect on May the 20th of 2026. The letters were sent by certified mail. The Postal Service receipts for each mailing are included in the summary immediately following the revocation letters. May 21st, 2026, in accordance with established procedure, Inspector Phelps reviewed the website advertisement for the property the day following the revocation date of May 20th, 2026, and he found that the advertisements remained posted and could be reserved for future short-term rentals. He made a site visit to the property, posted a stop work order on the door, which he documented with photographs. On June the 3rd of 2026, the appeal was filed. July 5th, 6th, and 7th, 2026, Inspector Phelps made site visits to 306 Pullen Avenue and found that the appeal notification sign was on the ground. On 7/7, the trash receptacle was overturned, blocking the driveway. On 7/8, Inspector Phelps placed the sign back in the upright position, and the trash receptacle remained in its overturned position until July the 11th. The photographs documenting this are included in the summary. July the 8th of 2026, the appellant emailed a lengthy summary of the appeal from his perspective, which I have included in this summary. There are a couple of items in this summary that I wanted to bring to the fore. The appellant's statement in support of reinstatement bears the hallmarks of a document prepared by an attorney. Yet there is no attorney or law firm associated with this document. That gave me pause. Additionally, the bottom of each page of the document indicates that it is an 11-page document, and the document we received was 5 pages in length. The statement asserts that this statement is organized around the standard the board applies under Metropolitan Code 6.28.035, whether the zoning administrator was in error or acted arbitrarily. As set out below, both are true here. For the sake of clarity, I've included the following definition of arbitrary. In legal terms, an action or decision is considered arbitrary when it is made without a rational basis, established rules, or supporting evidence. Instead, it appears that it is based on personal whim, prejudice, or an unreasoned choice disregarding the fair application of law or procedure. While legal systems often grant officials, such as judges or government agencies, discretionary power, the ability to make choices within the defined legal boundaries, an arbitrary decision goes beyond these boundaries, showing disregard for the principles of fairness and consistency and legal precedent. The evidence and documentation set forth in this Codes Department summary should dispel this assertion. Page 2 of the appellant's statement lists the following: documentary proof of primary residence, Tennessee voter registration at 306 Pullen Avenue. A Tennessee driver's license listing 306 Pullen Avenue as the home address. Federal, state, and state tax filings for 306 Pullen Avenue. A Nashville Electric Service utility account and bill in the owner's name at 306 Pullen Avenue. No claim of a homestead, exemption, or primary residence designated anywhere else. 306 Pullen Avenue is the only property the appellants claim as their primary residence, and short-term rental use that has been limited and incidental, consistent with the home the owners occupy and not a full-time investment rental. Inspector Phelps found that both the appellant and Ms. Tytko were registered to vote in Ohio on April 29, 26, as previously stated. Inspector Phelps also found that on April 29, 2026, there was an Ohio driver's license issued to the appellant on February 23, 2021, with the expiration of February 24, 2025, which previously stated. Cuyahoga County, Ohio property tax records for 1237 GEC Drive, Mayfield, Ohio, for the 2025 tax year includes an owner occupancy credit, previously documented and explained. Metro's compliance contractor, Granicus Host Compliance Tracking for the website advertisements for 306 Pullen Avenue recorded 22 documented stays from June of 2025 through May of 2026. As previously documented, the revocation letters were sent to both 306 Pullen Avenue, Nashville, and 1237 GEC Drive, Mayfield, Ohio, by certified mail, along with the postal service receipts for both. The assertion was made that the revocation standard was not met. The revocation is authorized upon determination of 3 violations. The appellants have no violations and no complaints of record across the entire life of the permit. There is no factual predicate for revocation on that basis. This is based on 6.28.030.A.5.L, denial and revocation of the permit. If the zoning administrator determines, based on reasonably reliable information the zoning administrator has obtained, including without limitation public records or reports, records of regularly conducted activity, or a direct or online statement against a person's own interest, that 3 violations of generally applicable provisions of the Metropolitan Code of Laws have occurred as a direct result of the operation of the short-term rental unit, the permit to operate the SDRP may be revoked if no appeal rights remain. However, this does not apply in this circumstance based on the owner-occupied SDRP affidavit signed and notarized on August 10, 2024 and submitted as part of the permit application. The last 2 sentences of this affidavit read as follows. I understand that knowingly providing false information through an affidavit is considered perjury in the state of Tennessee. I acknowledge that any permit issued based on false information is subject to revocation. The Atlanta address referenced in the statement is 2870 Peachtree Road, Northwest Atlanta, Georgia, 30305. This is a UPS store. There is an insurance upgrade dated April 1st of 2025, and there is an unsigned rental agreement which lists the landlord as 1237G LLC. This entity is registered with the Ohio Secretary of State with a registered agent in Columbus, Ohio. However, this entity is not registered with the Tennessee Secretary of State. The Tennessee Secretary of State received a mail-in application for voter registration from Jacob Petrosky on February 8th of 2025. But there is no voting history for him here. The next door neighbor at 308 Pullen, Ms. Rachel DeMont's support letter is included in the package. She also has an STRP permit. Her letter does not state specifically that 306 Pullen Avenue is a primary residence of Jacob Petrosky and Tracy Tytko.
Okay. Does anyone have any questions for Metro before we hear from the appellant? Please.
So because we're looking at a voter registration that was issued in 2025, is the assumption that they returned to Ohio and got a voter registration in Ohio as well, or subsequent to the 2025 date?
I'm sorry, I'm failing to follow your timeline.
And correct me if I'm wrong, I thought in the summary it said they when you checked with the Ohio Secretary of State, they had a Ohio voter registration?
That's correct. It was April 29th of 2026.
Okay. So the assumption is that subsequent to this January 22nd, 2025 date, they got a voter registration in Ohio?
In Ohio or Tennessee?
Ohio.
Ohio.
The question is, in the summary, we heard that this couple is registered to vote in Ohio. But now we have indication that Dr. Petrosky applied for voter registration in the winter of 2025. The Ohio registration, voter registration, does it predate that or does it come after that?
It predates that.
It predates that. We don't have anything of them going back to Ohio after the doctor applied for Tennessee voting, right? Going back to Ohio and registering to vote there, my apologies.
No, the assumption is that the Ohio voter registration had been in place for some time.
Right, okay. But there hasn't been any action to renew that since. Right. I'm saying though,
Well,
if you had come here and registered to vote, that would nullify your
No.
registration in Ohio?
It does not, and people get this wrong all the time. You have to affirmatively communicate
Ask to
to
be, yeah.
be taken off the voter
Yeah.
rolls.
Well,
Yeah.
if
In another
I
state.
may, that varies from state to state. And I believe that in Ohio, if you fail to vote in 4 election cycles, you're removed from
Okay.
the voter list. But again, that varies from state to state, so.
I think,
Okay.
correct me if I'm wrong, what we were trying to get at was any action taken after the voting registration in Tennessee to actively make an effort to vote elsewhere? And it doesn't seem that there has been.
I don't believe that there has been an election cycle during that period.
And no additional registration of any kind.
Yeah, in short, I'm just trying to determine how much weight I should give the voter registration.
That's your determination, sir.
Yeah.
All right. Anyone else have questions? Does anyone else have questions now that we've made it clear as mud? No? All good? Okay. Are we just gonna be hearing from you, Dr. Petrosky? Okay. So we're gonna have you open up by giving us your name and your address for the record, and then you have 5 minutes to tell us about your situation. And don't feel like you have to use it all. And I think we've all read your letter that you submitted, but please go ahead.
Okay. My name is Jacob Petrosky. I live at 306 Pullen Avenue, Nashville, Tennessee, 37207. And I'm appealing the zoning administrator's decision to revoke our license for a short-term rental today based on my assertion that this is my primary residence. I've lived here continuously since December 2023. To answer the question about the voter registration, that Cleveland voter registration was from 2018. And I have not made any efforts to vote or reestablish residency in Cleveland. I do own a house that I previously lived in before I was married. I've kept this house. It's now a rental investment property. And I believe overall this is a case of mistaken, I understand there's a lot of information online. A lot of it is outdated and has not been a priority to update. However, we didn't have any issues with the status of our short-term rental license since it was issued to us in October 2024. And so this was a bit of a surprise when my wife and I returned home from vacation to identify a cease and desist notice on our front door. I did provide some supporting documentation showing the insurance policy as a landlord insurance policy in the Cleveland, Ohio home. My new or recent current voter registration today, my letters of support by both of my immediate neighbors that have never indicated any problems or issues, and they support my request to reissue the short-term rental permit. As far as other supporting documentation, we have my current voter registration and a copy of my current driver's license. I think that it's a mistaken situation here, and so I'm requesting the short-term appeal board to look at the information provided and make a recommendation. And then that's all the time I need for right now. Now,
Well, we're gonna have questions for you, so I have a feeling you're gonna be able to cover anything you didn't cover. Can I start? Sure. Okay. Where do you work?
I work at a lot of locations, actually. I have I'm an independent physician. I have LLC, Jacob Petrosky, MD, PLLC, so I'm an independent practitioner. And I have credentials currently in several hospitals around the United States. I'm currently credentialed to work at 3 hospitals in Florida, 3 hospitals in Memphis, Tennessee, 1 hospital in Dixon, Tennessee. I work in Sitka, Alaska as well.
In bariatric surgery, is that correct?
Acute care surgery, general surgery, trauma surgery, and bariatric surgery, yes.
And this is the kind of practice that you can be kind of a free agent like that?
Well, so the kind of practice that I currently engage, it's called locum tenens. And so basically I fill in hospitals that need assistance. It's very flexible. I get to make my own schedule, and the overhead is very light. So it's the way that I prefer my practice.
And your wife, where does she work?
So my wife, she works for a pharmaceutical company. She's a fully remote employee, so she works from home, from Pullen Avenue.
So Dr. Petrosky, help me understand the restrictive tax credit claim in 2025. How does that happen if you're living here continuously since 2023?
I'm sorry, help you understand what again?
Help me to understand the tax credit in the state of Ohio that was claimed.
Oh,
the
okay.
property being your primary residence when you've lived here continuously since 2023.
Yeah, my guess, I'm not a real estate professional, and when I applied and purchased the home, that was my primary residence. And when I registered for the county taxes, and it's largely an automated process, I just pay the bill. I was unaware that there was a election, which I must have filled out when I applied for the mortgage for owner occupied. So essentially, I haven't been living there since the beginning, January 2022. So there's been this claim that is carried over by the county. I'm not sure why. I would say the county and the city, they probably don't talk to each other, because I do have an active permit for my rental home, so the city knows that it's a rental. And so my presumption is that this has just carried over on the county documents.
So the county is making a continuing representation on your behalf that this is your primary residence in order to make you eligible for a tax credit?
That's what it would appear, which I didn't know about before this situation.
Okay.
So we have had quite a few cases where homestead exemptions and primary residence tax schemes have come into play. And 2023, you would have benefited from that. 2024, you would have benefited from that. 2025, do you see where I'm going? This is a long-term situation where this has been considered, at least by the state of Ohio.
Yeah.
Your permanent residence and your sole residence as a couple. You provided a lot of documentation. What I don't see, and tell me if I've just missed it, any kind of permitting from the city or the county for your rental? Because you've provided a residential lease agreement but it's unsigned, and there's no, it doesn't seem to be something that was emailed so that it has a date and time stamp. This being submitted as evidence, I mean, really anyone with a word processor could have given me this.
Okay, sure. So the documents that I submitted were just to show an example of the different leases that we had. The rental application platform that we used to use when I had that lease that I submitted was like on their cloud, and I no longer have access to it because I've changed service providers. But that was a lease agreement with the date for 2024, I believe it was, to show just other support that I've not been living there. And that was the intention of my submission, to show that I wasn't living there.
I think what I'm trying to share with you is that, and I understand the intention was to show me somebody else lives there, I don't live there, but I'm telling you, I mean, I understand if you don't have access to the cloud anymore, but didn't you have any emails with the tenant about, oh, I only have 2 dogs, or I have 2 dogs, can we change this element,
Yeah.
I'm gonna park 2 cars there, like any kind of element in the lease agreement that perhaps you had communication with this tenant that you tell us you have, because this doesn't really, it doesn't really document that this is a real thing.
Okay, yeah, I'd be happy to provide that, but I believe there's not really a lot of guidance on what exactly to supply, so I provided some information I thought would be helpful. I do have numerous emails, I do have numerous documentation, but the packet that I submitted was already pretty lengthy.
Yeah, I'm just saying that we've got some problems to overcome here. The homestead exemption is quite a big hurdle to get over. If you had documentation, legit, that I could really hang my hat on, that showed someone else lives in that house, it would go a ways towards you convincing me that this hasn't been, that this was an error. It's hard, our job is to determine whether or not the zoning administrator made a mistake. And I'm not seeing stuff here that convinces me that he did.
I saw that my federal tax returns are available. Is that right? It said it was listed as one of the things that has my address on it, the federal tax return and the state tax return, because it would have all the documentation, the income coming from that property.
Let me ask a question, continuing in that same vein. So I've looked at all the documentation you provided. What I'm seeing is like the landlord policy declarations, all of that is active and effective as of either March or April 2025, but you got your owner-occupied short-term rental permit here in October of 2024. So what was happening on the property in Ohio between October of 2024, or, I mean, you say you've lived here since 2023. So what's been happening on the property in Ohio between 2023 and when the landlord policy went into effect?
The property has been rented out since February 2022, near continuously. I think in 2022, yeah, 2022, since we moved. We left Cleveland, Ohio. My wife and I moved to Vero Beach, Florida, documented my statement. And we lived in Vero Beach the entire time. We did not live in Ohio. And the property at Geesey, 1237 GS Drive or Geesey Drive, has been rented continuously since February of 2022.
Can I just ask legal counsel, if we're going to be having crosstalk here?
Yeah, it might be best for that individual to introduce himself.
Yeah. Since you're contributing, we need to know who you are and where you live, your role.
Yeah, hi, my name is Mike Clifford, and I live in Cleveland, Ohio. I'm in front of Jake's, and I kind of handle
Your address, please?
250 Plymouth Drive, Bay Village, Ohio.
Okay. And go on. Sorry, didn't mean to interrupt you.
No, I was just gonna say that, I kind of helped Jake with some of the communications on his rental properties. I've been helping him with communication for a couple of years on his properties, and the property at question here on Geesey Drive has been a rental property, and we have completely rented since I took over, or I started helping in 2024. Jake hadn't lived there for a while, but it's been continuously rented as a midterm rental. We have documentation of the income for the last couple of years. He maybe was there for, I think, a week, redoing a bathroom at one point when he came back to Cleveland. So they stayed there to visit and to redo a bathroom. But other than that, he hasn't been there. And I understand that the tax thing is an issue because that was overlooked, but he hasn't lived there in years.
I was just going to speak briefly on one matter. It's been mentioned that there are not specific documents in the record, namely, I don't know if the state or federal taxes are in the records. Metro is not obligated to base its record on any specific documents. Right. And additionally, if Mr. Petrosky wanted specific documents in the record, he did have the opportunity to introduce them.
Understood.
Right.
Terrence, please.
Excuse me. So the floor is open. Yep. So on that, glad you brought that up. So just do brief study as you were speaking at the Cuyahoga County Auditor's website. And it does not appear that you have to reapply for the exemption every year, but it does appear that you have to affirmatively notify the auditor if your status has changed with regard to the property. So if you were there in 2023, you qualify, you applied for it, you'd qualify in that year and then obtain the benefit the next year. And so then there'd be recertification periods periodically. And the last recertification period, you took advantage of the credit. How does that happen?
I think it just happens, it's part of the paying your semi-annual taxes, because I only ever filled anything out about living there when I applied for the mortgage.
My understanding from reading the website is they send you an application and you're obligated to send it back if your resident status has changed. And then I have a follow-up, and then I have a different line of questioning after this. Go ahead.
So I'm just trying to reaffirm, I only ever filled it out one time, and that was when I purchased the home. So I think that they carry it forward automatically.
They don't carry it forward automatically according to this website, which is operated by the county, unless they carry it forward if you don't tell them that your status has not changed.
Yeah, so they carry it forward because I didn't tell them my status had changed because I moved out of state.
Okay. So you're making an inaccurate representation to Cuyahoga County at this point.
No, that would be an oversight, not an inaccurate representation. And also my CPA would have missed it too. Okay. So it's not just, I'm sure it's a line somewhere that somebody need to update, which as I stated, I wasn't aware of that election until this issue came up. And you guys just brought it to my attention this afternoon.
Okay. So we heard from the city that your address as listed with the Tennessee Board of Medical Examiners is listed in Ohio. Is that still the case?
That would be the, so there's something called an interstate medical license compact. Mm-hmm. And so the IMLC would have that license, that address on file potentially, because my very first license in the compact was my Ohio license.
That very well may be the case. However, I'm asking a separate question about your address information that is on file with the Tennessee Board of Medical Examiners. That address, as far as we know, from the records the city provided, is Ohio. Is that still the case?
I would have to verify.
Okay. Because under those statutes, you have 60 days to change your address. If once it changes or it becomes a disciplinary issue. When were you first licensed in Tennessee?
I believe I was first licensed in Tennessee while I was still living in Florida. I have numerous licenses. I have 16 different state licenses.
Right.
So I'm not sure the.
But at one time, the license said Ohio. And when were you living in? When did you move to Florida?
I moved to Florida January 2022,
Okay,
and then I moved to Nashville, Tennessee, February 2023.
okay. And so your license, how did it ever become the case that it was in Ohio?
Because of the IMLC, my initial license, the initial compact license, I had an Ohio license before I ever had a Florida license and before I ever had a Tennessee license. So the IMLC license is likely based off of that initial license.
When you became credentialed here, you did not have an Ohio address.
No, I did not. I lived in Florida before moving to Tennessee.
So
Yeah.
based on that statement, that information should never have been provided to the Tennessee Board of Medical Examiners, who issues your Tennessee license.
Sorry, what?
I'm saying
Yeah.
that if you, once you became credentialed in Tennessee,
Right.
you are not living in Ohio.
No.
So that information should never be in these records that were provided to us saying that your license address, the associated address, is an Ohio address.
The associate license is associated with the Ohio license, and the Ohio license, the initial compact license, is the primary license for all subsequent licenses for the IMLC.
Let's set aside the compact issue because the Tennessee Board of Medical Examiners issues you a license that allows you to practice in Tennessee. That is a requirement.
Yes.
And in order to do that, you have to provide them an address, a residential address to which notices and other correspondence may be mailed. You are required to change that address within 60 days of a change of address. Given what you've told us before, it should have never been the case that that was provided to the Tennessee Board of Medical Examiners because you did not reside in Ohio at that time, correct?
No, you are correct on part of what you're saying, but the address that is required for notices to the state, that has been updated. And that address actually showed up in here. It's a 2870 Peachtree Road.
Okay.
That's the mailing address for all notices.
Okay.
So because of the initial Ohio license being part of the IMLC and my Tennessee license based upon the IMLC, the Ohio license is like the parent license, and then every other subsequent IMLC license is like a child license. And so that license propagates the information from the information that's provided by the Ohio State Board.
That doesn't change the statutory requirement, but it seems like we're belaboring the point a bit. I think I have the information I need. Thank you.
Please, go right ahead. Oh, unless, did you guys have anything to ask? Oh, yeah, let Diamond go first. Sorry.
Hi. So, in May of 2026, you received, it was a letter mailed out saying, or like a stop the work order that was put on your door. Did you see that once it was put up at all?
Yes, I saw that. It was put up on the 21st. I did see that.
Okay, and so when it came back on, I think, June the 7th, I believe, 5th, 6th, 7th, it was still like in front of your door on the ground. It was a complaint, I think that was said in April of 2026 that you didn't live there. So I'm just trying to see why was it still just on the ground at the porch in June if you had seen it in May?
Yeah, so I'm not sure what was on the ground, but I don't think it would have been that stop work order. The stop work order. Are
Yeah,
you
the stop
talking
work
about
order's on, yeah.
The stop work order, yeah, that was taped up. We took that down. We took that down and took it inside.
Okay,
So it couldn't have been on the ground anywhere.
that's what it's
Yeah.
saying in here, as far as the dates, I mean, correct me if I'm wrong.
It's not
It's
this.
the appeal notice.
It's the appeal notice, okay, okay.
Yeah, it's the one, right, that's on a set of posts?
Okay, yeah, the sign.
Okay.
Okay.
Yeah. All
All
right,
right.
we're good, we got
Okay,
it.
all right.
Is that all you need, Ms. Bell? Okay.
Why is your mail sent to Georgia?
It's sent there for privacy reasons. As a physician, I don't want patients or disgruntled people to actually get a hold of my actual real address.
But why Georgia if you live in Tennessee and you have a
so-
home in Ohio?
Yeah, Georgia, because I lived in Florida, and it's called a traveling mailbox. And so the traveling mailbox is a professional mail service. All of your mail is received, and they digitize your mail for you.
Okay.
So then I get secure access to my portal. They digitize and they shred all mail.
Okay. Got it. Thank you.
Anyone else?
Did you fly in here today just for this specific, because you said you live in Ohio, right? You, sir? And so did you fly here today or whenever you did, just for this specific situation? Okay, thank you.
Sir, if you're going to speak, would you mind turning on the microphone? So, just so you can be picked up?
Yes, I did.
Anyone else? Comments, questions? Go ahead.
If you moved to Tennessee in 2023, is there a reason you waited until 2025 to get registered to vote?
My driver's license wasn't going to expire. And so when the driver's license was getting ready to expire in February, I renewed it in January.
I'm talking about your voter registration.
Well, yeah, when I went to DMV, that's when I registered to vote, is when I got my driver's license.
Okay, so you had a driver's license for 2 years saying that you lived in Ohio?
Yes, I did have a valid driver's license that said I lived in Ohio.
Okay. I think the rule in Tennessee is, yeah. Okay, so for 2 years you were using an Ohio driver's license, but you lived in Tennessee and you didn't register to vote in Tennessee until 2025 because you weren't going to update your driver's license to show where you actually lived.
Yes,
Okay, got it.
Did you vote in the 2024 election?
I did not.
Okay.
Anyone else? Mr. Cash, you're so quiet today. Okay, very good. Okay, we are going to close the public hearing, which means unless we reopen the public hearing and pose a question to you, we're done talking with you guys. You may hear things in our discussion that you are inspired to interject. Please don't, because we have closed the public hearing. And then it gets into this messy thing, we're opening and closing. I'm just not good at keeping track. So we're not gonna have any more crosstalk with you guys unless we reopen the hearing. Are we good? Okay, you're welcome to stay there if you like. You're welcome to go back to your seats. And we are going to discuss this amongst ourselves. Who would like to start? Tom, you've been so quiet.
I'm sorry, you all got to,
We've covered a lot of ground today.
yeah, I mean, there were a lot of details there, and I'm not convinced at this point that Can you turn your mic? Oh, I'm sorry.
Oh, my gosh. Just
I
dropping
mean,
the ball left and righty today.
I am not convinced that the zoning administrator erred in his decision at this point, so, there's just too many, there are too many questions that I don't think were sufficiently answered.
Yeah, for me, the sort of holy grail is the homestead exemption. And that's the one thing I can't get over. And looking through the case, I can't find where the zoning administrator erred. There's some things that I'm willing to look beyond, but again, I can't find where they committed error.
Nicole, what do you think?
I agree. The owner occupancy tax credit is pretty dispositive to me. I think there's a lot of noise in the documentation, but if we're looking at, legal, formal representation to another state that you live there as your primary residence, I can't get over that because you're benefiting from a relief on your taxes in another state while then using your home here to also profit. So that's a tough one for me.
Yeah, we're very much on the same page. That was, that sort of just slammed the door shut for me, especially given what I read about how that process occurs and how you continue to receive the benefit of primary residence status in that particular county. And then also, I just can't make sense of all the other discrepancies with regard to licensing and addresses being listed for different pieces of government issue documentation. It just none of it quite none of it overcomes, none of it's enough to rebut the zoning administrator's determination.
I would also say the fact that he has a CPA doing his taxes in Ohio, like if he were doing it himself, I might understand an oversight like that, but a professional doing that for you, that's a huge oversight.
Yeah, and that's in the test function, so you can
Yeah.
get into some serious trouble with your license over
Yeah.
doing something like that
Yeah.
multiple years in a row.
Well, to that end, would anyone like to make a motion?
Yes, I will move, that we find that the zoning administrator did not err and, deny the appellant's request for relief.
Do I see a second? Okay, can I see a show of hands? Very good. Doctor, thank you so much for coming in today. We greatly appreciate your time and wish you all the best. You can follow up with staff. Okay? Thank you so much. Greatly appreciate your time. Okay, Mr. McBroom. Okay.
This is STR 2026-021, 515 27th Avenue North, number 3, Jody Junia and Beatrice Concepcion. Representative Hunter Akins, Sapphire Properties, expired permit. The property operated as an STRP with an expired permit. This is an MULA zone district where owner-occupied and not owner-occupied permits are both available. This is governed by BL 2020-187, 6.28.030. Upon the terminate, 030B5L number 6, upon number 2, upon the determination by the zoning administrator or zoning administrator's designee that a short-term rental property is operated without having renewed a previously issued permit, there shall be a waiting period of 6 months from the date of such determination by the zoning administrator or designee for the property to become eligible for an STRP permit. The board has discretion under BL 2023-136. November 20th of 2020, Jody Junia and Beatrice Concepcion acquired the property at 515 27th Avenue North, number 3, Nashville, Tennessee 37209. December 16th, 2020, a not owner-occupied STRP permit application was submitted. December 21st, 2020, the permit was issued. The information for the applicant owner provided on the permit application was the following. Applicant owner name, Jody A. Junia, Beatrice P. Concepcion, address 1016 Glendale Avenue, Nashville, Tennessee 37204, email address aho712@aol.com, and also the phone number was supplied. The contact information provided on the permit application was Ashwood Holdings, LLC, Chris Muscatello, 2534 Ashwood Avenue, Nashville, Tennessee, 37212, email info@ashwoodholdings.com. The contact address was later updated to 2023 Springdale Drive, Nashville, Tennessee, 37214. On October the 22nd of 2025, an auto-generated 60-day renewal notice email was sent to the applicant owner, and the contact email address is on file that I just described for you. The address for which the renewal notice was sent is an unmonitored, no-reply email address. On November the 6th of 2025, an auto-generated 45-day renewal notice email was sent to the applicant owner and the contact email, again at the same email addresses. There was no attempt to renew the permit in response to these emails. December 21st, 2025, the permit expired. December 22nd, 2025 at 12:14 p.m., Administrative Officer Alicia Buffer sent an email reminder to the same email addresses that the previous emails had been sent, informing the property contact and the owners that the permit for the property had expired on December 21st, 2025, and that the 30-day grace period would end at 11:59 p.m. on January 21st, 2026. The email sent to the owners email address came back as undeliverable. Administrative Officer Buffer then accessed the owner's phone number that is on file from the permit application. And at 12:16 p.m., she called the number and left a message. There was no response from the contact or the owners. December 22nd, 2025, the appellant emailed the STRP questions mailbox requesting that the property manager contact information be changed to Sapphire Properties, LLC, Hunter Akins, his phone number and email address at 313 Eisenhower Drive, Ashland City, Tennessee, 37014. December 23rd of 2025, Inspector Nicholas Owens made the requested change and email verification of the change to the appellant. At this point, the permit renewal grace period had just started, so the permit status was still issued as opposed to expired. There was no question about or request to renew the permit from the applicant during this correspondence. April 22nd of 2026, the address for this property appeared on a monthly list for April provided by Metro's compliance contractor, Granicus Host Compliance, of properties operating with an expired STRP permit. Inspector John Phelps verified that the website advertisement was posted and the property had operated with an expired STRP permit. Inspector Phelps sent a notice of violation to the appellant. In the time between the permit application and issue, the appellants had a new mailing address. It was previously 1016A Glendale Lane and was now 549A Moore Avenue, and the appellants failed to update the permit information to reflect this. The notice of violation was sent to the new address. On June 1st, 2026, Inspector Phelps reviewed the website advertisement for the property and found that it remained posted with new documented stays. Inspector Phelps made a site visit to the property and posted a stop work order, which he documented with photographs. June the 5th, the appeal was filed. As I assembled the documentation for this appeal summary, it appeared that the expiration happened due to three factors: the appellant's failure to update the permit information completely or on a timely basis, as the owner's email of record was apparently outdated. At the time the renewal emails were sent, the original property manager was either not responsive or had already been replaced, unbeknownst to our office. Given the date that the appeal was filed, June the 5th of 2026, the first notification that the appellant may have received was the posting of the stop work order on June 1st of 2026. However, on December 22nd of 2025, Administrative Officer Buffer accessed the owner's phone number that is on the file from the permit application, where she called and left a message. There was no response from the owners. Also, on April 22nd of 2026, the notice of violation was mailed to the appellant's new address of record. Again, there was no response. The last documented stay was in June of 2026. There was a previous Hub Nashville complaint on July the 10th of 2024 for advertising excess occupancy that was corrected within the remedial time period.
All right. Any questions for Mr. McBroom before we hear from the appellant? Yeah, please.
So was the permit renewed on a timely basis from 2021 to 2025?
Yes, it was.
Okay, thank you.
That was 4 renewals? Three.
Wait, no, 4.
4.
21, 22, 23, 24.
Yeah.
Yeah.
Okay.
Good? Okay, very good. So you must be Mr. Akins? Very good. Is that microphone open? Green light on. Okay. Why don't you start off by giving us your name and your address for the record, and then tell us about your situation. You have 5 minutes. Don't feel like you have to use it all.
Okay, is this on? You guys hear me?
Sounds like it's on.
Okay, cool. Turn it down?
No,
Oh, pull it down. Sorry, I'm short. Yeah.
yep. We thought we could hear him.
No, I'm just talking loud. Okay. Is this better?
Yes.
Just leave it. I don't need to keep pressing it. Okay, my finger was cramping. Thank you. Okay. Yeah, so I think the best example is playing a game of some kind and ball's up in the air, 3 people go for it, nobody catches it because everybody thinks somebody else is going to get it. So I want to first start by saying that me and my company honestly take responsibility for this and what happened, and we don't think that there was an error made on behalf of the city or Metro or John Feltz or anything like that. What we're asking for is essentially grace and understanding about what happened. So step one is what happened is the previous manager was negligent in a couple of areas in regards to the property, and Jody had, Dr. Jody Jr. had contacted us to manage his new property for him. He actually was transitioning a couple of properties to us at the same time. And during that process, we had other properties where, you know, during the transition, we took over at the end of November. And the other management company, when there was renewals for the other properties that came and went, they emailed us, they CC'd us, so on and so forth. And those properties were renewed, and then we let, you know, Jody know, hey, let's get all of this on the same page. Let's make sure that we're added as the point of contact moving forward. And we assumed that that was honestly all of them. And that was part of where our error was, is the assumption. So what happened was this last one to renew on December 21st, coincidentally, I noticed that we did not have this permit on record. At the time of what we were doing is we were just purely straight up putting things in a Google Calendar, and we were all referencing it. I realized, hey, I don't see a reminder for Jody's permit at this address. What's going on here? And look and find out, oh, we don't have it. But I didn't see anything otherwise. So coincidentally, I reached out on the 22nd. It had nothing to do with the fact that the permit renewed, had nothing to do with the notification received to us. I just happened to coincidentally reach out the day that the renewal was supposed to happen. So I reached out to Jody. He submitted that to the city and said, hey, update my manager. And we got an email back saying, yeah, your manager's been updated. That's your new contact information. And we got that email saying, yeah, permit's been updated. Had we just taken the 2 seconds to look at the renewal date on that document, would have saved all of us here time, and me and Jody, and a whole lot of headache. So that's where I say that me and my company made a mistake. I would have, at that time, it would have been great if somebody had said like, hey, look, your permit's been expired, but at the end of the day, it is the owner's responsibility. It is the manager at that time's responsibility, i.e. us. And so we did not know that we were operating without a permit. Had we known that we were within that grace period, I would have gone out Christmas Eve to make sure that permit was renewed, because that's what we do. And when we got the notice, because we didn't know, Jody didn't know, he is a doctor, he is busy, but I don't believe any of that information's up to date for him, or was up to date at the time. Now knowing that that's the address that was on there, I have since reached out, and we want to make sure that his personal contact information is up to date as well. But yeah, I guess moving forward from here is that we have since implemented software-backed processes to make sure that we also get notifications, regardless if we receive something from the city, not relying, quite frankly, on Metro to notify us, but our own processes. 60 days, 30 days, 45, because they all just went to the previous management, and he didn't renew it when it was under him for the 60-day or the 45-day. Then at the 30-day, it was under us. We're just going to rely on what we know about the permit instead of relying on others or assuming others, if that makes sense. So at this point, we're just...
That's the 5-minute mark.
Okay. Wow.
So, you did great.
So okay, sorry.
No, you're fine, you're fine. I'm sure anything else that you had to add will come out in the Q&A, so no problem at all. Who has a question?
Maybe one.
Go.
Can you clarify when you learned that the permit had expired?
When the notice was posted on the door.
So, about June 1st.
Yes, ma'am.
Okay. Great. Just a quick question, and it might just be interesting information that you never knew.
Okay.
So, December 21st, the permit expired. December 22nd, you just happened to email and get the contact name changed. Did you even glance at the permit when you were there? Because Metro very candidly has written here that because it was in the grace period, the status was listed as issued as opposed to expired. So I could imagine that would add to confusion.
Yeah, no, that's exactly what happened. So basically, this was all me at the time. It was my Google Calendar, it was all my processes, is that I was like, I don't see this on list, and you know what, we need to make sure that we're listed as contact for Jody so that the city will email us and let us know, hey, it's up for renewal. And that's what we have relied on for all of our clients, pretty much, is the city's emails. But we didn't get any because little did I realize at the time, the 60-day, the 45-day, and the 30-day had already been sent. And unfortunately, I did not check the permit itself online. It would have been a quick and easy fix right then if I had just gone to the website and looked at the status of the permit. I now have that bookmarked to make sure I can check for all of our clients at any given time. But yeah.
And just as you're keeping your Google Calendar up to date, keep in mind that
Yep.
those emails from the city are what's the word? A
Courtesy.
A
Yes, ma'am.
courtesy, thank you.
Yes,
not-
ma'am. They are a courtesy. They
Yeah,
are not a guarantee.
That is not what you can hang your hat on necessarily. If they don't send you an email, you still have to renew, right?
Yes, ma'am.
Okay, super.
Yep.
All right, who else has a question?
I do. I have a quick question. So in the transition from Ashwood to Sapphire, was there no sort of informational exchange saying, hey, here's what the...
Well, yes, initially, but I think as time went on, a bit of discontentment between the two management companies kind of grew. Well, you didn't do your job right. Well,
Okay.
you don't like how I do things, then you guys can figure it out kind of conversation is what happened. So when we initially so he had two other properties that he transitioned and Ashwood Holdings submitted renewals. They CC'd on us. Apparently they have like a full permit department within their company, and it was great. We got our information updated with that. It was no problem. But then, we just, part of the assumption is we thought, oh, that's all of them. Because we'd already had that conversation with them, hey, all the permits. But unfortunately, that conversation happened, I think, before the first 60-day notice went out. So he closed the doors and said, okay, well, they're going to get this afterward. And then they didn't respond. I don't know why the emails for them were listed as non-deliverable, but honestly, I don't know what I can do about that.
Because that was going to be my other question is when did those first transitional conversations happen? Do you know the date?
September. I don't know the exact date. You'll have to forgive me. Some of the properties we handled over earlier, because 3 properties is a lot to transition at once, because you have to understand the layout of the house and take inventory and so on and so forth. So we kind of did it 1 month at a time. So those first 2 was well within the period of where his management is extending over and we're going in and taking inventory while they're still under contract. And then this one, unfortunately, was just kind of like, okay, well, you want to stop talking to us? We're not having too fun a time talking to you either. We will handle this new one and it'll be fine. And that's, again, we should not have done that. It's the job of us to make sure as the manager that everything is handled over properly.
Gotcha. Thank you.
Come on, please.
Sorry. I'm just curious, when you became aware that the permit was expired, did you not remove the listing, or why was the listing not removed?
Does it say it wasn't listed somewhere? For my experience, we believe we noted it on the 1st, and then we had one booking that was literally checking in the next day, and we weren't sure about the process, so we emailed back and forth with, I believe, Ms. Buffer. I'm not sure, or maybe it was John Feltz, I can't remember. But we were in determination of like, okay, what does this mean? Because this is the first time that we'd actually had it happen. And so we honored that one guest. And then after that point, we unlisted the listing publicly, canceled all bookings, transitioned all guests that had been there, many hours spent with guests figuring out this is BS, this is unfortunate, so on and so forth. We did all that, if that makes sense.
Okay. I'm just trying to understand it, where that additional stay came from and what the last stay would have been in June.
I believe it would be June 2nd. I can look it up.
While you're doing that, Mr. Aiken, so you had a stop work order on the door
Okay.
or in the yard.
Okay.
Did you not have a letter also sent to the property?
No, ma'am.
No? Okay.
No, we did not receive any letter or anything like that. We don't have our mailbox checked frequently.
Okay.
Jody doesn't have access to it. He doesn't know how to access it to it. So quite frankly, we just have never opened that mailbox.
Yeah.
I don't know if it was sent to 515 27th Avenue though. I believe it was sent to the other address, correct?
Yeah.
Right.
Oh, yeah,
So-
yeah,
It was
it was
not-
sent
Because I
back
was,
to-
yeah, I
okay,
don't know
it was sent
what,
back as
I don't know
unfavorable.
that address unfortunately.
Does the stop work order not say, sorry, this might be for, doesn't the stop work order say to remove the listing, or is that only in the letter? Hold on, I'm looking at
Give
it.
me just a moment and I'll pull up a picture. I don't believe that the stop work order itself,
Oh, no, it does. It's handwritten. Lots of good information is in there. So, yeah, so that's actually, thank you.
well, it's either remove the advertisement or change the calendar to a minimum 39.
And that's exactly what it says. So, precisely. So the stop work order,
Yes,
I don't mean to come down hard on you, but
you're fine.
you had a guest that was checking in the next day, and you're saying, oh, I emailed and I didn't know what to do. Well, it's right there in red, short-term rental permit required. Please remove ads or change calendar to 30-night stays and stop short-term renting, right? I mean,
Gotcha.
that's pretty clear.
Also, given that the primary occupation of your business is to manage these things, I would think
Like-
that stop work order, you would know how to sort, you would know what
Yeah.
that means. Because that requires you to advise your client, hey, there's been a status change and we need to make some different arrangements.
Yes,
that
sir.
affect your cash flow.
Yes, sir. Yeah, I agree 100%. I think at this point, we were more so, like I said, it was the first time that we'd encountered it. I think that is written in plain English, and I 100% agree with you. I think at that point in that conversation was, I don't know if this is something that, honestly, I don't have an excuse. It's a good point.
Okay. So keep that in mind going forward.
Yes, ma'am.
Because I can tell you, this seems like a pretty innocuous case until it's, oh, there was a stop work order that said, stop short-term renting, and I rented to someone the next day. Okay?
Yeah,
That
I
doesn't-
do
That
want to.
doesn't fit with like what we want to hear.
Yes, ma'am. I do want to give the perspective of we're almost blindly focused on making sure that we don't inconvenience people as much as possible being in the hospitality industry. And I think our heart was in the right place of trying to make sure that we didn't inconvenience person who has travel plans and booked flights and so on and so forth for our stay for the next day. But again, that's the best I can come up with against that argument.
How many properties do you guys manage?
40,
40?
Yes,
And how
ma'am.
many does Dr. Junia himself own?
4.
4.
Yes,
And there
ma'am.
was no availability in any of the other properties?
No, ma'am.
The 40 that you own,
No, ma'am.
the 4 that he owns?
I'm good
Nothing?
at my job.
All
Yes,
right.
ma'am.
All right. Diamond, please go ahead.
On the 22nd, when you did reach out, when Miss Buffer called your phone, the 615-973, who phone?
She called the owner's
Oh,
phone.
the owner's phone. Okay, okay. So that was the same day that the information got changed, correct? And so once there was a notice sent out to the new email address on record, that also was not seen as well?
I don't
Which
believe,
was, it would have been in 2026?
I don't, 2026? I'm sorry.
It was mailed. There was a notice mailed. There was
Just
not.
mail, not yet.
Yeah.
And you're saying that you didn't get that at all because y'all don't check the mail regularly?
I don't know if it was
It
sent to
wasn't sent to
515
the
27.
property. It was
Yeah.
sent, everything goes
Yeah.
to the owner. Everything went to the owner. And it seems like the owner didn't have his contact information updated and so was not receiving
All of the
notices.
information that should have been had at the time.
Yes.
Yes, ma'am.
Got it.
The previous management company, I believe, entered in their own information for that content rather than the actual owner of the property. Because
Yeah.
Jody Junia also said, I have received no phone calls, I've received no emails. Because after this, we said, have you received any letters? Did you get anything? Did you think this was spam? And he said that he did not receive anything. So we think the initial setup of the permit, the previous management company put it all direct forwarding to them.
Got you. Thank you for that
Yes, ma'am.
clarification.
Yeah.
Anyone else?
One more.
One more, please.
I don't think we've ever seen you here before. Is that correct?
No, ma'am, I am brand new. Yes, ma'am.
Okay, and you don't want to come back, right?
No, ma'am, I do not. It's cool. Y'all seem like nice people, but please don't have me back here. And I'm gonna do everything I can not to be back
Thank
here.
you. Appreciate it.
Yeah.
Okay, good. All right, we are going to discuss this amongst
Okay.
ourselves. You can go back to your seat if you like. And we will reopen the public hearing if we have any more questions for you, but don't interject even if you hear something that you want to address, because the public hearing's closed. Okay. Please, go ahead.
So first of all, I want to say that if I'm not mistaken, I think we've seen Ashwood Holdings come up in at least one other case. Yes. So that to me indicates that, like, that makes me believe that there is an issue with the previous management company that was not operating in good faith necessarily. I appreciate the honesty, and what I always like to see is what have you done to correct this moving forward? So noting that there have been new processes implemented, I appreciate that. The one thing that is bothering me is the stay after the stop work order. I understand from a hospitality perspective, but from a, like, you're gonna show up in front of us and ask for relief, it's very difficult for me when there was a knowing violation. Like, up until June, I get it, wasn't aware,
Yeah.
everything fell through the cracks, it was a mess. But once you get the stop work order and then you have another stay, that's very difficult for me.
Yep, you hit the nail on the head. I mean, I'm still a little tripped up on the handoff process. I just feel like, and maybe this is my lawyer mind, but the first thing I'm gonna ask is, hey, do we have the right to actually continue operating, or is there anything that we need to do to secure that right before we actually take over and I know when you're thinking day-to-day operations and not necessarily status, your mind's gonna go somewhere else. But for me, the first consideration is going to be, let's make sure your license is valid.
Yeah, I think I think just that confluence of dates and inconveniences and coincidence there at the end of the year definitely would give a false sense of security, like, oh, your permit's updated. And, oh, you look and it says issued. Okay, well, so let's move on to the next thing to worry about. I could very much see how that would happen. And I think the analogy of, 3 people going, you see it with fly balls in baseball, it does happen.
Yeah, no, that's a good analogy.
Not in the majors so much, so that's, something to think about going forward, but.
Well, Nashville is not the majors.
Yeah, that's right. It's a little league thing, so we need to be more professional, right, in this kind of an environment. But yeah, that one stay after is the only thing that keeps me from being like, let's just forget the whole thing.
It's sticky. Yeah.
Sticky. So I think, yes, relief, maybe not as generous as we might have been had
Correct.
that stay not happened. I don't know, what do you guys think?
I'll just echo what my fellow board members said. I don't think that anything was done maliciously or, to move in a bad manner. So for me, the stay knowing that the stop work order was there, because, it is plain as day. But other than that, I don't think that it's any other thing that I would say or add.
Yeah, I'm aligned with everyone else. I'm probably just gonna float a number, something like 120 days.
So 4 months,
4 months.
okay.
Okay,
From June
when?
1st?
That's the big question.
From the last documented stay?
Right, which is a 1-day stay, wasn't it?
I don't know.
Do we need to reopen the public hearing to find that out?
Should. June the 2nd.
I thought June the 2nd was a checkout date.
That was check-in.
Check-in, excuse me, that
So-
was check-in.
Let's call it June 3rd.
Okay,
Split the difference between
Perfect.
the stop work order and the appeal.
okay. So that would put us at, what, September 2nd? Can I count? No, I can't count.
July, August, September.
July, August.
No, that's 3 months.
Okay, so
that's 90 days.
October
It would
2nd.
be October 2nd.
Yes.
I would argue for 90 days. I think that 3 months is it's a serious penalty. And I think that the appellant was honest, forthright, and has taken steps so that it doesn't happen again.
I'm comfortable with that.
I'm cool. And it's a mixed use zone, like you know.
Tom,
Oh,
this is-
please, go ahead, Tom.
Thanks. I'm in agreement with what y'all are saying. There's one thing I want to ask, and maybe this is a staff question, that I kind of don't want to get lost here. So December 23rd, the appellant, on 22nd, 2025, the appellant emailed STRP questions, but then on December 23rd, Inspector Nicholas Owen made the requested change and emailed verification of the change to the appellant. At this point, the permit renewal grace period had just started, so the permit status was still issued. I'm just trying to visualize that. Like, is that relevant to, like, he got an email, and so in that email was the word issued on there? Like, I think early on, the appellant made a mistake, and I think he said like 2 seconds, or he'd taken 2 seconds to look at something. But I'm just wondering if there's an opportunity to make a form or notification clear about something like that.
Yeah, I did not love how the city worded that
Yeah,
email.
that-
said
there
the
was some-
permit
I
is-
wanna
yeah,
make sure that-
I didn't love that either.
I'm not saying we did anything wrong, the city did anything wrong, but I just wonder if we could do, I can't visualize it.
Okay, at the end of the day, let me preface my answer by saying, we've been over backwards in this case. We really did.
Okay.
And none of this is compelled. I mean, the ordinance does not force us to do this.
I understand.
Second-
I'm not saying you did anything wrong.
Second of all, the references to when the permit is pulled up on the computer screen, in the upper right-hand corner, there is a status, and it is issued, and it remains issued until the 30-day grace period has expired and the permit has not been renewed.
And I guess what I just am a little unclear on is if that was something that was visible in the email that the appellant received.
No, that would not be.
That's just somewhere else.
That is just the City Works screen that comes up when you access that permit.
I got you. Okay, thank you.
All right. I mean, I don't think anybody's arguing against 90 days. What do you guys think? Do you think that's too lenient? No? Shall we make a motion?
I'm on the fence.
Okay. You don't have to vote for it.
Yeah, I probably won't.
Okay. Hey,
I'll make a motion.
okay.
I move that we find that the zoning administrator did not err in his determination that the property operated with an expired permit. However, given today's testimony and the factors discussed, we would allow the applicant to apply for a permit 90 days from June 3rd.
Second. Can I see a show of hands? Okay, we have 4-1. Got that? Oh, I'm sorry, you're voting against. I never do that. I always just assume. Okay, yeah. I didn't know if you're abstaining. I mean, anything could happen. Okay,
Parliamentary procedure is very important.
very good. Okay, so we're good. You can follow up with staff on when you can reapply. Best of luck. Thanks for your time today. Okay, third and final case of the day. Oh, God.
Yeah, yes, but I'm always hot sometimes.
You see this?
Yeah.
Okay, this is STR 2026-022. Eustathiou Sparks Revocable Trust, Natalie Eustathiou, 2406 Alameda Street, owner occupied, permit revoked. The STRP is not the principal or primary residence of the owner permit holder. This is an RS5 zone district which allows only owner occupied permits. This is governed by BL 2020-187 based on the date the permit was issued. 6.28.030.A.2.C. To qualify for an STRP owner-occupied permit, the owner of the property shall permanently reside at the STRP, or for conforming uses in single-family and two-family zoning districts, the owner shall permanently reside in a residential unit on the same lot. The owner of the property must be a natural person or persons, may not be a limited liability entity, including without limitation a corporation or limited liability company, and 3, may not be an unincorporated entity, including without limitation partnership, joint venture, or trust. The board has discretion under BL 2023-136. On July the 3rd of 2018, the appellant acquired the property at 2406 Alameda Street, Nashville, Tennessee, 37208. March the 29th of 2023, Ashley Sparks and Natalie Eustathiou acquired the property at 1316 Olympia Road, Venice, Florida, 37293. On July the 6th of 2023, an owner-occupied permit application was submitted for the property. The application was processed and issued. I would like to note the time on when the property was purchased in Florida and when the owner-occupied permit application was submitted. September the 11th, Ashley Sparks and Natalie Eustathiou moved the property at 1316 Olympia Road, Venice, Florida, into the Eustathiou Sparks Revocable Trust via a special warranty deed filed with the Sarasota County Circuit Court Clerk. On January 21st, 2026, the property at 2406 Alameda Street was quitclaim deeded to the Eustathiou Sparks Revocable Trust. This is a violation of the STR ordinance as previously cited. To qualify for an STR owner-occupied permit, the owner of the property must be a natural person or persons. The address on the address was on the list generated by our permit issuing staff for properties with STRP permits for which the property owner's name does not match the name of the owner at the time the permit was issued. This list is generated because the STRP ordinance dictates that a change in ownership voids the permit. This list recorded the owner's address as 1316 Olympia Road, Venice, Florida, 34293. We opened an investigation into primary residency. The quitclaim deed that was the deed of record at the beginning of the investigation lists the owner as Eustathiou Sparks Revocable Trust with the owner's address at 1316 Olympia Road, Venice, Florida, 34293. May 15th of 2023, Inspector David Feltz emailed the appellant informing her that the change of ownership caused the STRP permit to be voided pursuant to MCL 6.28.030.8.2.c as stated at the beginning of the summary. The assessor of property for Nashville and Davidson County lists the owner's mailing address as 1316 Olympia Road, Venice, Florida. The Metropolitan trustee also lists the owner's address as 1316 Olympia Road, Venice, Florida, 34293 on the property tax bills for the years 2024 and 2025. Prior to that, they listed the owner's mailing address as 2406 Alameda Street, Nashville, Tennessee, 37208. Ms. Eustathiou's LinkedIn page states that she is a licensed psychologist in Tennessee and Florida. The Florida Department of Health has a current license for the appellant that was issued on June 4th of 2020 with an expiration of May 31st, 2028, where the address of record is 1316 Olympia Road, Venice, Florida. A browser search for Natalie Eustathiou yielded a Psychology Today bio for the appellant, which lists her locations as Nashville, Tennessee, and Venice, Florida, states that she is available online only. There is a notice of commencement dated on June the 2nd of 2025 and notarized in Florida for installation of hurricane protection at 1316 Olympia Road, Venice, Florida, signed by Natalie Estathiou, which was filed with the clerk of the Circuit Court of Sarasota County, Florida on June 24th of 25. There's an underground easement document signed by Ashley Sparks and Natalie Estathiou on June the 23rd of 2025, and a notarized in Florida, which was filed with the clerk of the Circuit Court of Sarasota County, Florida on June 24th of 25, which records Ms. Estathiou's address as 1316 Olympia Road, Venice, Florida. The tax collector for Sarasota, Florida for the 2025 tax year lists the owners of 1316 Olympia Road, Venice, Florida as the Estathiou Sparks Revocable Trust, Natalie Estathiou and Ashley N. Sparks trustees, with a mailing address as 1316 Olympia Road, Venice, Florida. Ashley Sparks' LinkedIn page lists her as the Vice President of Denials at Enable Comp in Venice, Florida. Her LinkedIn history shows that she has been employed with Enable Comp for 5 years and 3 months from April 2021 through October of 2023. Her work location with the company was in Franklin, Tennessee. Soon thereafter, her work location with the company was moved to Venice, Florida. Ashley Sparks has an automobile registered at 1316 Olympia Road, Venice, Florida, and a current Florida driver's license at that address. Both the registration and license were issued on December 11th of 2023. Ms. Sparks also registered to vote in Sarasota County, Florida on December 11th of 2023, and as of May 15th, 2026, her voter status is active. May 15th of 2026, Inspector Phelps emailed the appellant informing her that the zoning administrator has determined, based on the evidence that I have just listed, that the permit was not to be renewed due to lack of primary residency, again pursuant to MCL 6.28.030.8.2.c. The entire email chain is included at the end of this summary. May the 26th of 2026, the appeal was filed. On May the 28th of 2026, the property was quitclaim deeded from Estathiou Sparks Revocable Trust to Natalie Estathiou with the owner's address as 1316 Olympia Road, Venice, Florida. July the 8th, the appellant submitted a lengthy summary of the appeal from her perspective, which I have included in this summary. I will depend upon the board to compare the two summaries and draw your conclusion. However, I will point out that the appellant summary email states, my wife has been assisting her elderly mother in caring for her disabled brother in Florida. I believe that our evidence clearly establishes that her wife, Ashley Sparks, resides in and is employed in Venice, Florida since at least December of 2023 and possibly as early as October of 2023. July the 9th of 2026, as of this writing, our office has received 1 letter in opposition and 2 letters in support.
Great. Any questions for Mr. McBroom before we hear from the appellant?
I'd just like to ask one clarification question.
Please.
Just given the record. On July 6, 2023, the statement is an owner-occupied permit application was submitted for the property. I just want to confirm that property is 2406 Alameda Street.
That is
given
correct.
The previous property mentioned.
That is correct.
Good call. Thank you. And I have lost where, oh yeah, please go ahead.
So, would you say, I see that you're saying very clearly that her wife lives in Florida. Does the codes department believe that the documentation indicates that Natalie lives in Florida?
I believe that if you go through the documentation that is presented in the summary, that there are numerous legal documents that Ms. Estathiou has signed indicating that her address is in Venice, Florida.
Okay,
Numerous documents.
okay. And apologies for referring to you by your first name. I don't know how to pronounce your last name.
Oh, no worries.
Okay,
I'll
that was all I
pronounce it
had.
now. Can you hear me?
Okay, we can, but give
Oh, sorry.
Ramon 1 second to ask a quick question.
Yeah, just quickly, so Was the permit revoked because, this is not their primary residence, or because of the quick deed, the initial quick deed change to the trust?
No, the way the ordinance reads is if there's a change of ownership, the permit's voided. However, we generate this list because there are instances where it's changed to a trust or an LLC for protection or for taxation. And they get bad advice from either their tax person or whomever. And really, in those cases, if we revoke the permit, you know, they come to us for relief, and their issue is with the person that gave them the bad advice because they're acting as their agent and they're supposed to be a fiduciary. So we really want to try to avoid those kind of things from happening because in general, it's an honest mistake. So that list is generated and we go through it and we notify people, your permit's voided due to the fact that you had this ownership change. And we give them an opportunity to rectify that. If they respond quickly, in a very timely response, we will allow that to be changed back to the owner to whom the permit was issued. But that was not the reason for this. That was just what initially brought this to our attention. And it was coupled with the fact that the owner's address was listed in Florida. So we had to open an investigation based on that information. And that's in accordance with the ordinance as well. But no, it was not a revocation. It was very close to the time that the permit was due to expire, and we just said we will not renew the permit based on lack of primary residency. Nothing to do with the change of ownership.
Okay, great. Thanks for the clarification.
Question for council. What does the voiding provision say? Because I'm assuming it's just by operation of law. Once you make that status that the code doesn't recognize, then there's.
I think you're correct that operationally it's just says it's void.
Right. But so the city has a practice though of allowing a grace period for you to correct that mistake.
Yeah, the zoning administrator is allowed that discretion.
Okay.
And to clarify, that's not the issue here because it's back in her name now, right?
Absolutely not.
Okay, great, thanks.
Yes, I was trying to find out the date on which the quitclaim was made from the trust back to the individual owner.
It's in here.
It was in there, and I.
May 28th, 2026.
And the original quitclaim to the trust was when?
January 21st, 2026.
Okay, so a period of 120 days. Okay.
All right. We good?
Yes.
I am not going to butcher your name, so you can introduce yourself and give us your address for the record and tell us about your situation. 5
Yes.
minutes, and don't feel like you have to use it all.
My name is Natalie Eustathiou, and I reside at 2406 Alameda Street, Nashville, Tennessee, 37208. I'm asking the board to reverse the denial of my owner-occupied short-term rental permit renewal because I have continuously maintained my permanent residence at 2406 Alameda Street since purchasing the home in June 2016. I want to begin by acknowledging several facts that are not in dispute. My wife resides in Florida. I co-own a home there with her, and I maintain a Florida psychology license in addition to my Tennessee license. I have never attempted to hide or dispute any of those facts. The question before the board, however, is not whether I have ties to Florida. The question is whether I, Natalie Eustathiou, permanently reside at my home on Alameda Street in Nashville. The objective evidence demonstrates that I do. Throughout the relevant time period, I maintain my Tennessee driver's license. voter registration, Tennessee psychology license, my Tennessee business, my utilities, my medical care. I have an emergency room visit there, which an emergency is simply that, an emergency. I couldn't have planned it, that I've also included in there. Although I provide telehealth, psychotherapy, I also perform psychological evaluations under contract with intermediate care facilities throughout Tennessee, many of which require me to conduct evaluations in person because the individuals have severe or profound intellectual disabilities and I cannot assess them through telehealth. Earlier this year, I transferred my Nashville property into a revocable trust as part, and actually the trust I think we initiated in September. It was in David's email. I didn't familiarize myself with the timeline, so I don't know if he's accurate with that, but it sounds right. And I didn't transfer, the lawyer was a Florida lawyer, and she advised me to obtain a lawyer in Tennessee because I wanted also my house to be in Nashville, my home, to be in the trust. And when Metro informed me, so this was January when I moved that there, and in May, when it was about time for my renewal, Metro informed me that the trust created an issue with my permit renewal, and I immediately followed their instructions and transferred the property back into my individual name. I've attached emails between me and David. Today, I will present the evidence demonstrating that my permanent residence has remained 2406 Alameda Street and respectfully ask the board to reverse the denial of my permit renewal. Thank you.
Who has questions?
I don't have a question, but I did want to thank you for providing so much documentation. I know it probably felt like overkill when you were putting it together, but it really helps us because it can be difficult to prove where you live, but when you provide documentation that demonstrates that you are doing the regular things of life in a certain place, then I'm assuming that's why you provided those various items.
Absolutely, yes.
Okay, thank you.
Anyone else have a question? Can I ask a question? And this is, you may not even have insight into this, but have you discussed with your wife, is it because of her work that she has to live in Florida? Like, could she not be, or her brother and her mom? I mean, is it?
Can I answer now?
Oh, please.
Oh, yeah.
The
So
question is to
we
you.
planned this. It wasn't, her mom is not disabled. Like, she's elderly.
Yeah.
But she does have to care for her brother. And this is something we planned. Obviously, we purchased a house for her to stay in, you know. So
Right.
that took time. And I started on my Florida license, you know, just so I can be able to have flexibility, because telehealth is a new thing for therapists, and I'm old school, you know, and I try to make sure that I'm covered, you know. If I happen to see a client through telehealth in Florida while I'm visiting my wife, I don't want there to be a problem. So, and you know, I feel like I'm a teenager, but I'm aging, and so my supervisors are aging too, my psychology supervisors, and some of them unfortunately pass away. And when you apply for a license in a state, you need to show certain hours of supervised experience and things like that. I don't want there to be an issue if I, you know, I'm just a planner. There's one thing I didn't plan for that's, I'm sure it's gonna come up in the questions, but I'll let you guys resume. That was my answer, thanks.
Please, go ahead.
Yeah, and it's interesting because my question's actually on the screen now. So when the property was claim deeded back to you, or back in your name, why the Venice, Florida address?
So actually, as I was reading what David sent to the board yesterday, it's the first time I realized that the Olympia address is on my tax document for my house. This is the first time that I saw that. And I can't explain that. It's been there, I can't explain it because it's been there since 2024, and I don't know what triggered it. But, or 2022, when does it say? It at some point in the last 2-3 years, it changed. And I remember the DMV called me, and I was having issues with mail, because the DMV called me and said, your registration came back to us. It's undeliverable. It was delivered to the it was taken to the 2406 Alameda Street, and it was marked as undeliverable. And so I was like, what's going on? And then I was also having issues with my office, my mailing address in Nashville for my business. The same thing. So to answer your question, I think what happened was the house was moved to the trust, and but my recorded mailing address for the in the counties, the zoning was listed as the Florida one. And so when the lawyer in Nashville changed it back to my name, they never changed the address. So it was switched back to my name, and they left the mailing address the same. And I didn't notice it. So I hope that wasn't too lengthy, but.
No, that was perfect. Thank you.
All right, thanks.
Anyone else? Terrence? Okay. I did want to, if it's okay, and not to split hairs, but I always read with great interest the back and forth between the folks in Metro and the appellants. And I kind of thought it was a little bit telling, your email with David Freybutt, right? Like one of your first ones in May 22nd. You say, I have longstanding personal and business ties to Tennessee. I own and operate a business in Tennessee, conduct business in Tennessee, and file and pay taxes in Tennessee. My home has historically been in my name, except during periods where my wife and I made estate planning related adjustments. While my wife currently lists Florida as her residency, she also works for a Tennessee-based company and works there part of the year. David goes on to explain to you that if your wife lives in Florida, then you live in Florida, or if you live, like the presumption is that you guys live together. And then your tone changes in the response that you say, I would like to clarify that Tennessee is my primary residence. It's like your initial email with him gives this like living in two worlds, which I think is probably your situation. And it's not until he pushes back and says, you can't have it both ways, then you're like, no, it's my primary residence. Do you not read it that way?
So, I don't know if this is a good answer, but as a therapist, I wear different hats. I have to do paperwork. I have to do assessments. I don't have an administrative assistant to take care of phone calls, schedule appointments, cancel appointments. And so a lot of my interactions with David were in the middle of my workday in between clients. And sometimes I'm sorry to say, but I use ChatGPT sometimes just to keep things moving. Because if I stop, I'll forget something. So yes, my tone has changed because I, was typing into it and saying, this is what I want to say. So if my tone's changed, it's because it's chat, it's not me. I was just trying to understand where David was coming from, especially since he said, yes, it would be sufficient for you to change you know, put your name back onto the house, because you know, and then a week later, so I'm a planner, so when unpredictable things happen, it just throws me off. Thanks.
Okay. Does anyone else have any questions or clarifications they want?
Just a quick thing, if you don't mind me asking. I know you said that you and your wife planned it because she got to take care of her brother and her mom. Did you move to Nashville strictly because of a job, or what made you say, hey, I'm going to stay here and you're going to stay in Florida?
I've been in Nashville since 2009. I came as an international student, and I graduated from Tennessee State University. So I've been in Nashville for a long time. I actually got naturalized in Nashville. Nashville has been my home for a long time. And Alameda, sorry, I'm getting emotional. Alameda is my first home.
I don't blame you for not wanting to move to Florida, personally.
Okay, any other questions? Excellent way to end that. Okay, we're gonna discuss this amongst ourselves. You're welcome to stay there if you like. You're welcome to go back to your seat. Unless we reopen the public hearing, we're probably not gonna have any more communication with you though, okay? Great. This is a tough one because unlike other cases where we've had a married couple that lives apart and these claims have been made, this does seem to be a married couple that truly lives apart. And it's tough because I feel like we need to treat appellants equally, and we haven't made allowances in the past for this. Please, go ahead.
So I would also say we haven't seen this type of documentation in the
True.
past.
That is absolutely true.
To me, we've had people come in and say.
And claim it.
This, but they're actually registered to vote in another state and their driver's license is in another state. Oh, but I can explain that.
Yeah. Oh, and their kids go to elementary school in another state.
Yes, exactly.
No, I know.
Everything that we've been provided by the appellant, to me, you don't get your oil changed in a state you don't live in. You don't end up in the emergency room just by happenstance. You were in Nashville when you had to go to the emergency room.
Right.
All of these, like,
yeah, and routine care is being given here too. No, I completely agree with you.
So,
I'm just
so
saying
for me, it's not a tough one.
But what are we gonna do the next time somebody comes along and we say husbands and wives are presumed to live, or spouses, excuse me for saying that, spouses are presumed to live together? What do we?
Right, but that's the
okay, please.
rebuttable.
This is why we have attorneys.
That's the point of our board, is the rebuttable presumption.
Exactly.
Yeah.
Nicole said the magic word. It's rebuttable. It's you know, the assumption under the law is that that is the case. However, if there is evidence that we find to be credible that that is not the case, then we take that into consideration and weigh it.
Okay.
It's interesting. Nicole and I agree, but for totally different reasons. And I actually disagree with the city's stance on what the legal effect is of transferring the property to the trust in the first instance and then not transferring it back to the individual until 5 months, 4 or 5 months later. I went back and read the code because I was very, very curious as to exactly what it said. Based on the reading of that code section, it does not appear to me that the zoning administrator has discretion, or at least not enough discretion, to set up an entire separate process by which they allow them very generously to transfer the property back. And certainly, even if they did, I don't think that a reasonable amount of time is 4 months. So I think that the zoning administrator erred simply because I think that we're talking about the wrong code provision here.
But it wasn't that caused her to lose the permit.
No, but that was an exercise of discretion by the zoning administrator. The code provision to me is quite clear, or not ambiguous, in saying that when there is a transfer of ownership and the zoning administrator finds that there has been one, the license is void, the permit is voided. And that is a singular act, is by operation of law. There doesn't have to be any other finding other than that and that's not disputed in the record. It was changed back 4 months hence, but the code in my reading is unambiguous as to that point. Ultimately, I don't think the zoning administrator erred here, but for different reasons.
Okay.
That issue is not before us, though, right? We don't take up issues that are not before
But that's because
us.
that's what they decided that the issue was. They framed the issue. I just think they framed it incorrectly. That's my only argument.
I think functionally it would end up in the same place where they would be
Yeah.
coming to the board asking for
We would
charging.
be denying a new application if, to me, if the issue were framed correctly, we would be examining whether the denial of a new application was proper because the person did not live there as their primary residence.
Rather
as
than the
opposed to-
renewal?
Right, rather than a renewal, a denied renewal. It may be splitting hairs, but to a person that does what I do, it's an important distinction.
Splitting hairs is your game.
That's what I do.
That's right.
That's what I do.
Okay, well, nevertheless.
But Nicole and I agree either way.
Okay,
That's all I need.
what do you guys think? And you haven't been on the board as long, but you know, we've been through this with other cases. But as we were saying, other cases are pretty egregious.
Yeah, in the last meeting that I was with Nicole, it was kind of, well, something similar to this, but you could tell, like, he clearly didn't live here. I feel like she, like Nicole said, brought in so many different documentations, and I can't imagine how hard it got to be to, knowing that, you know, your wife is going through that where she is, and then y'all are so far apart. But yeah, I have seen the difference between a person that doesn't actually live here, but saying that they are, and then somebody that actually does, while also being in a relationship, being a spouse couple, whatever they may be.
The weight of it's a 196-page file, so the weight of the evidence definitely favors the appellant.
Yeah, I don't know that I have a lot to add, except, you know, there's still the issue of the quitclaim deed having an inaccurate or out-of-state address, which,
Well, her wife lives there. So, I mean, and
True,
what
but-
I heard was she's having mail issues at her
Yeah.
address in Nashville. So that personally doesn't bother me, but I hear what you're saying.
yeah, I mean, you can't apply for a permit or renew your permit with an out-of-state address. Or
Well,
at least that's my understanding.
you have to provide a variety, like you have a variety of different things to choose from. But then the zoning administrator can look at other documentation.
I think that the address was on the quitclaim, but not on the application.
Fair,
Don't get me wrong, it's not great.
yeah.
Yeah.
It's not great. But I think this is in other cases, like, it's been, like, just preponderance of
Yeah.
evidence
Yeah,
in favor of this being nonsense. And in this one, it's like,
Yeah, I've been on the boards for 6 years. This is as close to a good faith error as I've ever seen.
yeah,
yeah,
I don't know.
yeah, I won't dispute that. I perhaps do have some concerns about, you know, future cases. I think, Terrence, you won't be here to hold us,
I know.
to keep us honest.
I feel like this board actually does a really good job of keeping determinations really close to the facts.
Yeah.
Well, when we have the docket come out, and it's, you know, couples who live in
Yeah.
different cities, and I'm gonna have you come back as a special guest star,
Yeah,
okay?
Well, those are always very fact-intensive determinations, and I think that we always dig very deeply into the evidence that's presented to us and what was true at the time the determination was made, because we've also had people come before us that have since rectified their situation. We're like, well, the remedy, unfortunately for you, is to reapply.
Yeah.
Is to reapply once you're able.
Okay, so here's another topic for discussion. I don't really think that the zoning administrator erred with the information he had. So can we say we're granting relief to reapply even though we don't see an error? Even though it seems to me that the only way Ms. Tuspew could reapply is if the zoning administrator had erred, because we're not really offering relief. We'd have to negate the finding.
We have to believe, though, that the factual determination that the zoning administrator made was true. And if all of these facts that were later brought to us via the appeal were also true at the time, then I think that the zoning administrator's determination does become erroneous. Because it's not like those things became true after the fact. They were true at the time that the determination was made. The zoning administrator just didn't have the evidence in front of them.
Learned counsel
I would
agrees.
agree with that. Functionally, you've been presented more evidence than the zoning administrator had. You could say they were not in error, however, we find that given the evidence in front of us.
Okay.
Because previously, it's always been a subsequently you did all this stuff. But
Yep.
Yeah, this is all contemporaneous.
All right. I have to say, this makes me very uncomfortable
I hear that.
because I feel like we are going to be, our feet are going to be held to the fire by every couple that has some, pardon me for saying it, BS story, because there are a lot of them.
Yeah.
Well, I would say that our board does a very good job of sifting through the BS.
All right.
I think we are highly suspicious in general.
That was the word in my mind. I didn't know if you were going to go there.
And for me, I've explained why I think that this case is different than other cases that we've seen. And so I'm ready to make a motion if that is okay.
It's all right by me?
I would move that the board find that the zoning administrator did not err, given the evidence available to him at the time of his determination.
No.
Did not err, given the evidence available to him at the time of his determination. However, based on the evidence provided to the board, we find that Miss
Efstefeu?
Efstefeu does in fact live separately from her spouse, Miss Sparks. Miss Efstefeu lives in Nashville.
Second? Second from Ms. Diamond. Okay, can I see a show of hands? That's a big win.
I did.
Yep, it was unanimous.
It was unanimous.
All right,
Might have been.
now, before we call this meeting to a close, it is with a very heavy heart that we have to say goodbye to our friend, our fearless vice chair for how many years?
Yeah, it's been a while.
Terrence, you have been a joy to work with, an absolute joy. Joy to get to know. You are a great guy and a wonderful Nashvilleian, and we are lucky to know you and to have you in our community. And he's going off, not because he's lazy and doesn't want to continue serving with us, but because he does so much for the city of Nashville, and it's just his time is being called upon by other needs.
Yeah, balancing is a tricky thing these days, but I must say, I was kind of dragged kicking and screaming into board service by a former zoning administrator who I still owe a good talking to in some really colorful language at some point, but this has been the most wonderful surprise. This is an extremely conscientious and considered group of professionals. I think we take the job that we do very seriously. I think we care about growth and we care about people being able to exploit their property for financial gain, but doing it according to the law. And I think we strike a really nice balance. And so whether it has been for a period of weeks in certain cases, months, or years, I've truly enjoyed working with each and every one of you. You've made me a better thinker in this process, and I will treasure these memories for as long as I have a memory. So thank you.
What? When can she reapply? Straight away?
Yeah, immediately.
Tomorrow?
Tomorrow.
Yeah, tomorrow. Okay, sorry, yeah. Because we said. She lives here. She lives here, so, okay, yeah, all right, thank you.
So I need to do the whole initial process?
I believe you do. Okay, but you'll be all right. Okay. Today's meeting is concluded.
And,
Well, it was nice knowing you, Mr. Terrence.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information on this and other programs, visit nashville.gov.
boat off the coast of Sardinia when you guys were meeting.
And this is the
And I
first
didn't
time
miss it one bit.
I have essentially concurred in the judgment.